I will tell you that anytime a young attorney came to me and said, listen, I'm kind of new at this, and I don't really know for sure the best way to approach this, that person immediately got from me a more of a mentoring approach to plea bargaining. I didn't give them a different offer, but I explained it. And I might say to them, you know, I want you to take a look at this case. I just pulled it off. I want you to read it, and that kind of thing. So try not to pretend to cover up, perhaps, your inexperience with bravado. I think it's huge. If you're inexperienced and you don't know what you're doing, own it. And you might find that people will be willing to help guide you, and don't automatically assume that simply because the system says that that person is an adversary doesn't mean they're going to not treat you fairly if you're honest with them. Remember, we talked about being honest in your dealings with your adversary.
A criminal complaint done on a summons or a warrant, doesn't matter. You know, with almost mathematical certainty, that the statistical probability of this case ultimately being tried is 2%. Very, very, very remote, okay? Just given the total population of cases, very, very remote. So you know going in as a defense attorney that this case is going to be resolved in some way other than a trial. The likelihood, depending on the case, but assuming that there's evidence to support the charge, it's going to be pled out, okay? You've got to know that going in. You can't be, you know, it's unrealistic to expect that there's going to be some resolution of the case other than a plea, okay? Which means that you've got to kind of start thinking about the plea process very early on in the history of the case, and kind of get your client's expectations ready to roll, because unless you see something that's worth trying, the case is going to be resolved without a trial. So knowing the statistical imperative, knowing the statistical probability of a trial being very, very remote, you've got to set your client's expectations very, very early on in the process. What are your thoughts about that?
Refreshing. That's a refreshing way to look at it. I have to tell you, I never really looked at any of my cases within that statistical probability. Mm-hmm. But the truth of the matter is, that's exactly what happens. Most cases, when they come in the prosecutor's office, are resolved other than with a jury trial. Mm-hmm. So if I represented the person charged, I think that that's one of the things I would like them to understand early on. And it helps, I think, as you navigate the discovery process, because what I normally see is that they're in the process of gathering witnesses or gathering information in order to have the trial, and that's an awful lot of time wasted. What they should be doing is gathering their facts, but really thinking in terms of what's a reasonable resolution, right, short of a trial. It
is improper, and never do this as a matter of professionalism, you young lawyers out there. You do not involve the judge in the plea bargaining process. Don't plea bargain in front of a judge. Just keep the judge out of it. The judge has nothing to do with it. However, if you're at loggerheads and you can't decide on something, it's perfectly proper to go to the judge and say, Your Honor, if we pled out to XYZ given these factors, what would Your Honor think would be an appropriate range of sentence given these factors?
Can I just emphasize, because I know you know it, but you didn't actually articulate at that moment, when you go to the judge, you go with your adversary? It goes without saying with you and me, but sure. Again, we're talking to
young attorneys. You would never approach a judge without your adversary.
Yes, like, can we speak to the judge and see what the judge's reaction is?
And by the way, I mean, sometimes the judges will want to do this in chambers, but I think you're always better off doing this on the record.
On the record, in front of your client.
Right, and you might want to alert the judge to it ahead of time in writing or whatever, but it's always best to do this on the record. That way there's never any question about it. But you don't want to put the judge on the spot either. No. You gain nothing by putting yourself in an adversarial position with victims. Nothing. It will hurt you and your client in the long run. The better thing is to be, again, to the extent you can, collaborative and sympathetic with victims, and try to get them to the point where they're going to be made whole. Because your client's obligation to make them whole is going to be part of every sentence anyway. Whether that's going to be done through money or jail or something else, that's going to be in the mix. So I think if you put yourself in an adversarial position with victims, you're really hurting your client. And I just wanted to see what your thoughts were.
You're also hurting yourself and your reputation as a professional. Mm-hmm. I have more than once watched the victims' witness advocates in the Camden County Prosecutor's Office work with victims. And it is a tender, important process that they can become heard. They're heard, they have certain rights, they have an opportunity to provide an impact statement. How has this impacted me to the court? And it is something that just by voicing how these things happen to them and how it's affected them helps them get to that made whole. As an attorney, even if you're asking for a restitution hearing because you challenge the value, the amount of money they're asking.
Or the ability to pay.
Or the ability to pay, you don't need to be disrespectful. They've already been victimized. You're not going to advance your client's interest by being disrespectful.
By the way, I just interrupt you for a second. See, now you and I are talking about something, again, that we're just assuming that everybody knows.
Sorry.
In terms of the case law, talking about the balancing act that judges have to do in the vast majority of cases between, fines and restitution, the ability of the defendant to pay. Because typically that's in play in every case, with the sole exception, once you've liquidated the amount of the restitution, that's in play in every case except where, like, I think there's one example where you're stealing electric.
Right.
Then restitution is required regardless of the ability to pay. But this just kind of underscores the point we were making before about why you have to know sentencing law in New Jersey in order to do your job.
That's exactly right.
I'm sorry, but
No, it's fine. So my thinking is that creating an adversarial process with the victim of a crime, particularly now that we're at a point where we're even thinking about pleading guilty,
right,
advances no interest of the defendant whatsoever.
Right.
And as an attorney, you need to advance your client's interests in the best way possible. So you can certainly respectfully explore the values that are being placed on it or the ability to pay without making the victim a victim again in the process.